Christian, you may begin.
Thank you. So, table 11, these will be tables up here actually, examining the issue of the legitimacy of being born outside of the United States and having American parents and whether or not you would be eligible to run for presidency. So, the person in question, his name was Thomas Smith, and he was born in Mexico to a Mexican mother and an American father, and at the age of 10 moved to the United States and became a California senator. So in accordance with the U.S. Constitution and current legal statutes, we determined that he would be eligible to run for president in the 2016 election. His natural-born status was verified by his father's U.S. citizenship, and by the time he would assume office, he would be at the age of 35 and would be 25 years a citizen of the U.S. We examined the legislation passed in 1954 and 1972 that liberalized the definition of natural born to extend to any person born to an American citizen regardless of the geographical location of the birth. We also searched for a real-world example that would kind of mitigate that claim. And we examined the 2008 election in which John McCain, who was born to American parents but was born in Panama, was still eligible to run for the presidency. And so that's what we determined.
Excellent. Very articulate. Well done. Are there any other positions on that issue? Is there a dissenting view?
No, it was unanimous. No. No, the decision was unanimous.
Decision was unanimous. Excellent. Well done. I want to recognize the facilitators and, of course, I believe, constitutional guide who was involved. I believe it's Mr. Lashes. Is that correct? Where is he? There he is. Hiding? Thank you. The next issue. Let's proceed with issue number 2. You have 1 minute. Each spokesperson has 1 minute. So issue number 2. Issue number 2, for those of you who are interested, deals with an issue concerning gay marriage. Gay marriage that was recognized in the state of Vermont. And the couple moved to Mississippi. Over time, the marriage deteriorated, as approximately 50% of them do, and they wanted to seek a divorce. They tried to seek a divorce in Mississippi, however, Mississippi claimed that they do not recognize gay marriage. The question is, does the Privileges and Immunities Clause apply, as well as any other constitutional issues that might arise? I'm not sure. I believe that's the issue. Go right ahead. Proceed. Introduce yourself, sir.
Is it on? Yeah. Okay. My name is Miles Brown. I'm a Round Rock High School senior, and I'm doing my 3rd semester at ACC for early college start. Okay, so the issue was whether or not the Article 4, Section 1 full faith and credit clause should affect if Vermont or Mississippi accepts Vermont's marriage, and the Attorney General said it doesn't. Under Mississippi Constitution, the state constitution says they do not recognize gay or same-sex marriages, but the full faith and credit shall be given in each state to public acts, records, and judicial proceedings of every other state. So the AG was unconstitutional when he said that they could not get divorced because the Constitution says that anything given in one state must be recognized in the other state that it is in. So constitutionally, the AG should have allowed them to get divorced, even though their marriage accepted in that state.
Well done. Nicely argued. Are there any other views or positions on the issue? Introduce yourself, sir.
Hello, my name is Jordan Rojas. I'm a junior at Henderson High School. And I'm speaking on behalf of the legality of Mississippi's decision. And while I do agree with Stacey and many others that same-sex marriage and rights should be recognized in advance in all states, forcing Mississippi to recognize the Vermont marriage by proxy through granting of a same-sex divorce is actually violating their full faith and credit clause, because this is holding Vermont's laws over theirs. This goes on to, or as that is granted them in the Constitution, as Amendment 10 goes on to note, the power is not delegated to the United States by the Constitution, which one of those is that of the right of marriage, or nor prohibited to it by the states, are reserved to the states respectively or the people. So thus, by forcing Vermont to actually, or forcing Mississippi to recognize this marriage by proxy, it's violating their full faith and clause. And because Mississippi had laws prior to this, prior to the union being formed, saying that same-sex marriage is not allowed, while it is not morally right, it is legally justified based on the fact that the United States Constitution says that all laws that are prohibiting something when it comes to states' rights should be recognized. And since this was a marriage, since this was after the writing of the Constitution, it should be held to a higher precedent than that of Article 4.
Thank you very much. Well done. Imagine that group had a very lively discussion. Do we have any other views? Not bad, huh? Sounds pretty good to me. Any other spokespersons from that group? Well done. Facilitators and constitutional guides. Let's proceed to issue number 3. Issue number 3 deals with Iran launching a nuclear attack against Saudi oil fields and the consequences that occurred. Who are the spokespersons for issue number 3?
I'm Levi Waters. I'm a senior at Eastview High School, and I'm taking my first semester of ACC.
Welcome. Proceed.
I am against, given the scenario of St. Louis being destroyed by atomic weapons, the question is, are the actions of the president at that moment constitutional? And although majority of my group agreed with his initial actions, which was to nationalize all state National Guard units to supplement the U.S. Armed Forces.
I won't take time away from you, but just to give the rest of the group some context, what occurred was a complete breakdown within the United States. We responded, the President of the United States was killed as part of the attacks. The Vice President took over, conditions were chaotic, and the President of the United States decided to be able to maintain order, to take over a number of powers. What were some of the powers that he took over, sir?
He took it to his hands. He assigned U.S. Armed Forces to retaliate, and he also nationalized the trucking, railroads, flight, airlines, other departments of transportation, also energy companies.
And a variety of others in the interest of national security. The
Yes.
question is this constitutional?
Yes.
And that's what you're addressing. Proceed.
Yes. And although most of my group did agree with one of his first actions, which was he supplemented the U.S. Armed Forces to both foreign and domestic services, I cannot find anywhere in the Constitution that justifies his actions for nationalizing the companies. To my understanding, Congress has this power, but they do not belong to the president. And in this scenario, Congress was absent. They were on leave. So, and to my understanding, the president does not inherit Congress's power while they are absent. So that is why I found it unconstitutional.
Thank you very much. Well done, sir. Are there any other positions on this very intriguing Yes, sir.
I believe that,
One moment. Introduce yourself.
I'm Elijah Benwees. I go to school at ACC Rio Grande. I'm a freshman. This is my first semester ever in college.
Well, good to see you.
Good to see you too.
Proceed.
Okay. I believe that the actions undertaken by now President Biden were constitutional. The justification he used to ensure domestic tranquility, which is outlined in the preamble, is ruled by the Supreme Court to be not a valid justification of federal rights. But it does say also in the Constitution that the president may, in extraordinary occasions, act on behalf of the Congress in a way to ensure that the laws be faithfully executed. And there are certain presidents in the United States Constitution, such as the Takings Clause in Amendment 5, the Interstate Commerce Clause, all of which can be used to justify nationalization of the trucking industry, of the energy industry. And this specific Article 2, Section 3, I believe the president could make an argument that he was simply making sure the laws were being faithfully executed, and in that capacity, in the situation of this extraordinary circumstance, he was acting constitutionally.
Well done, sir. Logical, thoughtful presentation. Excellent. Are there any other speakers on behalf of any other position that applies to issue number 3? Seeing none, let's proceed to issue number 4. Issue number 4 involves a search at an airport. An ACC student returning from a trip to Turkey is stopped. His laptop is confiscated, and all that it contains is revealed in the process of the investigation and the search. Question is, did Homeland Security have the authority to do that? Do I see a spokesperson?
Yes, sir. My name is Keith Brown. I'm a student at ACC. I'm a history major. And to go over the first issue, can this information be used to convict the person who they seized the laptop from? We had a general consensus that it is unconstitutional. Under the Fourth Amendment, it states that you have to be issued with a warrant or have probable cause, and it specifically says that they picked this person at random, therefore breaking the Constitution. The second portion of this was, can this information be used to arrest the other conspirators that were on the laptop? We had two different opinions at our table. The first opinion is that being that the Fourth Amendment only covers the person that's directly being related to, they would still be possibly able to be convicted. And we had another person saying that it was a moot point because they violated the Fourth Amendment.
Sir, well done. You summarized your entire group's positions, even the one that you didn't embrace. Well done. Thank you.
Hello, my name is Hema Barrera. I'm a freshman college student at Riverside, and I'm studying general sciences.
Welcome.
Thank you. So the search involved occurred at an airport, which has the same equivalence as that of a border, and the country does have a primary interest of protecting border security. So right off the bat, travelers should know that they need to have a reduced expectation of privacy when crossing the international border, simply because people's safety could be at hand. Furthermore, regard the emails that were found in this man's laptop, included some emails about blowing up some elementary schools. So regardless of whether those emails were true or not, people's lives are in danger. So this is why this government should use this information to convict Joseph Abba.
Stop. Lawyers, judges, did you hear that? Did you hear the mobilization of legal doctrines to make an argument? Somebody learned a lot of law in a short amount of time and presented it very well.
Thank you.
You are very well. Are there any other spokespersons for issue number 4? Seeing none, let's move on to issue number 5. Issue number 5 deals with a very controversial issue that is very much alive throughout the country and in the state of Texas, a constitutional issue, the issue of a right to an abortion. Who is our spokesperson on this question?
How's it going? My name is Sam Gittler. I'm currently a senior at Anderson High School.
Yes, sir. Proceed.
So we talked a lot about the 30-mile restriction where you have to have an abortion clinic within 30 miles of a hospital that will admit people with complications. And we said that it was unconstitutional to require the hospitals to admit these patients just because a lot of them being privately owned would not work. But also the 30-mile restriction is unneeded because there's only a 0.7% complication rate, and in Texas there's nearly 0 deaths in all of the statistics shown. We also talked about that there's just really no way to enforce that a doctor that can admit patients to a hospital can be there, and the fact that they have to be present in order for the abortion clinic to be up and running is unconstitutional and is in fact an undue burden.
And a violation of presumably the women's right to have an abortion.
Yes, sir.
Understand your conclusion, understand your argument, because you made it so well. Thank you, sir.
Thank you.
Are there any other positions in that group?
I'd just like to give a shout out to Ms. Fobbs.
Sir, you're out of order. That may apply in high school, it doesn't apply in college. Next. Let us proceed. We're on issue number 5. Issue 5. Do we have any more spokespersons for issue 5? No? Seeing none, let us move to issue 6.
We're doing teamwork.
Hi, introduce yourselves.
Hi, everybody. My name is Cecilia Marco. I'm Ashley Thompson. Our issue was on the United States Congress passing authorization for the president to order an attack on Syria, and then stating that the president went over his boundaries as they declared. Although our group did not support the authorization Congress passed, but given the authorization was vaguely worded, for example, number 3, degrade Syria's capacity to use weapons in the future, the president's powers were constitutional under Article 2, Section 1, as Chief Executive, and Article 2, Section 2, as Commander-in-Chief.
Well done. Clear, succinct, and to the point. So you're saying the president did have the power to authorize the attacks on the oil fields in Syria?
Yes.
Okay. And ma'am, you are?
I am Ashley Thompson.
And Ashley, do you have a alternative position or a dissenting view?
No, I actually support hers. I don't know, he had the authority, but we don't agree on it. I think we got that as a whole. It also stated that congressional resolution that Congress authorized by stating the President is authorized to use armed forces of the United States as he determines to be necessary and appropriate.
that the congressional authorization, the language in the authorization, permitted the president to take the action that he did. Is
Yes,
that
sir.
correct? Very good, both of you, outstanding job. Thank you. Let us proceed. Do we have another spokesperson? Go right ahead.
Good evening, I'm Virginia Roberts. I'm a junior and I attend multiple ACC campuses, and I am in opposition to the president having the right to declare this. Optimist Liberation Art Group agrees in general that declaring war is not the first choice nor the best choice in the case of Syria. Some reasons backing this is that it's posing a war without imminent threat. Our group felt that Syria has not presented an imminent threat to the United States. Our allies are saying, no, we do not support you. We will not back you. What is our interest in it? What cost is the U.S. willing to pay to go into a war? And it was proposed to be a limited war of up to 90 days, but what really is limited? We feel it was a violation of the congressional power to make the attack, and as an alternative, we would prefer to see an act of diplomacy taken before war.
Well done. Thank you very much. An issue that certainly is in the news. You had a chance to debate and discuss it. We are on issue number 7, I believe. Issue 7. Spokesperson? Introduce yourself, sir.
My name is Joshua Thompson. I attend ACC at Round Rock, and I'm majoring in music theory and composition.
Yes, sir. Go right ahead.
Our conclusion, at least at my table, excluding one of us, was that the execution of Anwar al-Awlaki was unjustified because he was not given his right to due process as an American citizen, whether or not he was in or out of the country. In this case, he was in Yemen. And even though his speech may have been a credible threat, words are just words and should not have enabled the United States government to take action.
So you find the conduct unconstitutional?
Yes, sir.
Thank you. Well done. Good point. Do we have a dissenting view? Is that the consensus? Are you speaking, sir? We have someone at the microphone right now. Are you speaking?
Yes, sir.
Are you speaking on behalf of issue number 7?
Yes, sir.
Okay, go right ahead. Introduce yourself.
My name is Ibrahim Temde.
Yes, sir.
I am here at ACC. I am the ACC Northridge Senator. I have been at ACC for 2 semesters, and I love it.
So do I. Go right ahead.
What our panel concluded was similar to what the gentleman back there said. So we are of the opinion that the issue wasn't taken into account because, for the most part, it hasn't been explored enough. When we took into account the 5th and 14th Amendments, the right to fair trial, grand jury, he was given that, as well as the provisions granted by the 14th Amendment, the provisions which are the doctrine of incorporation. We feel that the government has taken steps too far in the modern era, and hence was our viewpoint on the decision.
So you find it unconstitutional, but you find it unconstitutional based upon different reasons. Is that correct?
Yes, sir.
Well done. A concurring opinion. Thank you. out of an abundance of caution, are there any other views or positions are to be presented on issue number 7? Yes. Boy, issue number 7, that's been an exciting group. Let me bring it on.
Good evening. I was the only person that was in the minority.
I'll proudly announce your name.
My name is Reese, and I'm a student at ACC.
You certainly are. Proceed.
I'm an anthropology major.
Go on.
Okay, so we are discussing Anwar al-Awlaki, and Anwar al-Awlaki was executed by a predator drone in Yemen because he supposedly was mixed up with wrong people in the United States and was involved in Fort Hood, the shooting there. So I think that it's completely constitutional that he was executed by a predator drone because if he was not executed, the American hegemony would completely fall. The way that we've seen examples of American hegemony fall were in Iraq and Afghanistan. They basically gave him speeches just like this guy was doing. So how exactly could we have gotten him is an important question, because this is the only way that we could have gotten him in all reality. So upon cost-benefit analysis, what it cost the United States and what it benefited the United States is something that we have to realize was extremely beneficial, even if it might go against some of your personal views.
I want to stop before anybody says a word. What this gentleman just did, whether you agree or disagree, epitomizes what this night is all about. The ability and the right of a single individual to articulate a view different from everyone else. The Bill of Rights protects against the tyranny of the majority. And it provides people like you and each and every one of you with the right to articulate your views. Well done, sir. Anyone else in that group? Seeing none, let's move on. We're at issue number 8. Issue 8. Attention. I have to selfishly say I am so proud to see my students volunteering for this. They know I don't bite. Good to see you. You're all doing great. Hi. You'll get your credit. Don't worry. Before we move on, let's wake up for a moment. This issue deals with enhanced interrogation. This is the issue dealing with, really, border. So, I am waiting with bated breath for the results of your deliberations. So, introduce yourself and tell us what you found.
My name is RJ Rowan. I attend the ACC. So, while debating this topic, we came up with one main question that we asked ourselves, and that was, does someone who has prepared or preparing to commit an act of terror on innocent population of people deserve certain rights? And we said no. And because by committing this act of terror, the terrorist is inflicting cruel and unusual punishment on a population of innocent people. Therefore, he does not deserve the constitutional right of not being cruel and unusually punished. Also, the Fifth Amendment does not apply to him because you're not asking him to incriminate himself. And finally, the emergency of the situation would create an exception to the 14th Amendment.
Well done. I'm proud of you. Thank you. Do we have any other views from that group, or is that the consensus? No, we have another view. Excellent. Introduce yourself.
Hi, my name is Allie Smith. I'm a
Hi.
mathematics.
Go on.
Okay. Although most of our group was torture him under these provisions, who's to say when it may not be acceptable. Also, it will lose confidence in protecting our citizens and the innocent. Thank you.
Excellent job, well done. And again, we see an individual with courage being able to express a view that may not conform with the majority. Well done. Any other views from that group? Seeing none, we're moving on to issue number 9. Issue 9 deals with the whole question of voter identification. Do we have a spokesperson to speak on that issue?
Yes, sir. My name is Matt Corey. I'm a second-year ACC student.
You may proceed.
Came out against this voter ID law, finding that according to the 14th Amendment, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deny any person within its jurisdiction the equal protection of the laws. In Amendment 24, the right of citizens of the United States to vote in any election shall not be denied or abridged by the United States or any state by reason of failure to pay any poll or other tax. Being that the voter ID law would put a financial burden on impoverished people and elderly, we will see that it would actually be viewed as a poll tax. Legacy of Texas as a Section 5 state is that we really like to suppress voters. This I find to be abhorrent. In the state of Texas, the past 10 years there have been 51 cases of fraud, and only 4 would have been prevented by this law. This law does nothing but disenfranchise voters. If you disenfranchise one eligible voter, then the whole system might as well be thrown away because you've ruined the rights of any, it could be any one of you who wants their rights to be stepped on. Thank you.
Thank you. Very good argument. Any other spokespersons on that issue?
Yes, our group voted for this law, actually. My name is Svetlana. I am attending the Rio Grande campus at ACC and majoring in psychology. And so what we talk about is that he already spoke about the problem about the fraud. We would actually say that picture IDs or ID voting would protect your right to vote. We would provide free IDs, so there would be no cost associated with that. We would have a better accountability as well as accountability, and it would actually, who would not be motivated by knowing there would be less fraud if you go vote, and to make you feel that your vote actually really counts. And about the older people and the less fortunate people, there would be other ways to make it accessible. We, for example, was talking about making picture IDs available at the voting booths so that we would take pictures to put it in a system and actually save it there for next year and so on. And that way we will, from that point on, always, happy.
You show a lot of courage speaking up there. And all of us should give you the courtesy of listening. So finish your thought.
No, basically I'm done. I would just,
Do you find it unconstitutional? You would find that it is constitutional.
Yes, we are voting for
The
this.
voter ID is constitutional. Thank you. Any other spokespersons for that issue? Let's move to issue number 10. Issue 10 deals with the University of Texas Law School admissions policy and the question of alleged reverse discrimination. Do we have a spokesperson? We do.
her civil rights were violated of the equal protection of laws. There's a statement in there that the equal protection clause limits the abilities of states to discriminate against people based on their race, origin, gender, or national status. And for her to score higher than any one of the other people in the minority groups, and for her to be denied admission to UT was quite unconstitutional in our eyes. I mean, it was looking at UT's makeup. Their website says that they are 51% white and 49% minority. And according to the U.S. Census, the state of Texas is 44% white. And it just doesn't seem that affirmative action is the underlying cause behind that. It's good enough, minorities are good enough to get into their universities that they would like to go to based on their status alone. They don't need additional help.
Well done. Thank you. Thank you. Are there any other, this is a controversial issue, are there any other positions on this question? Yes, ma'am.
Hello everyone, my name is Nina Jones. It's my first semester here at ACC Northridge, and I would like to say that UT was not discriminating against Anglo-American acceptance, but instead they were pressured to act because here it says Black and Hispanic legislators were pressuring to increase the number of minorities in law school or lose funding. So UT did not act on racial discrimination itself. They were striving to reflect racial makeup of Texas and increase diversity in schools instead. Substantive due process under the 14th Amendment states that more than, and I forgot my little booklet, if someone could help me out.
You're doing fine.
Thank you. Kira. All right. It says that more than offering a process of fairness,
What
courts have
says?
found.
Take a deep breath. You found your source. What are you referring to?
I'm referring to the substantive due process under the 14th Amendment.
You're referring to the 14th Amendment to the United States Constitution.
Yes, sir.
Good.
It says that.
So the rest of the group can look up the 14th Amendment to the Constitution. They have copies of that and refer them to the particular portion of the 14th Amendment that you are relying on as authority.
Right. It says that more than offering a process of fairness, courts have found that the 14th Amendment prohibits states from harming an individual's ability to fully participate in society just because UT rejected. Are my minutes up?
I'm giving you more time.
All right. Just because UT
Your minute
rejected
was up a long time ago, and I've given you additional time, and I did not take it off of your speaking time.
Appreciate it.
You can finish your position.
UT did not prohibit Ms. Hooper
higher than any of the other minority groups, and also that she scored higher than 50 of the whites who were accepted. Now I have to point out that if she scored higher than any of the minority groups and still pretty low in the white section, doesn't that point out that there's already some discrimination inherent in society? Doesn't the University of Texas, isn't it compelled to sort of make up for that discrimination? Maybe other races didn't have as much of an educational opportunity in the K through 12 system. Maybe they do need to be given some sort of consolation when they get to the university level in order to eventually bridge the gap and, unify races, get rid of racism. I mean, reverse racism is wrong. It's as wrong as racism is. But how else are you going to take any steps to make sure that minorities can get into college? That's
Good for you. You made a policy argument less than a constitutional. Thank you. Any other spokespersons on that issue? You must have had a very interesting and lively discussion in that group. Seeing no additional spokespersons, I think I may have gotten some issues confused. Let me go to issue number 11. Issue 11. Or number 1. We did 11 first, my mistake. Issue number 1.
So just for some brief background on the issue at hand.
Introduce yourself.
Yes, my name is Zach Falkenberry. I'm a junior at Hendrickson High School. And the issue we're dealing with here today regards a law passed by the state of Texas requiring all students to say the Pledge of Allegiance in schools. The issue at hand comes inherent within the Under God clause in the pledge itself. And many atheist parents sued the state of Texas on behalf, claiming that this was an infringement of the establishment of religion under the First Amendment. And so, in order to clarify such hot topic issues as this, it's important to note that it's not about whether or not the phrase under God should be taken out of the Constitution or not, but rather if the state should mandate it. And when looking to pass precedent of issues such as the West Virginia State Board of Education versus Burnett, or the Elk Grove Unified School District versus Newdow, it's important to note that not only do past court cases set the precedent that students are not required to say the Pledge of Allegiance in school in the first place, thus making this law inherently unconstitutional in and of itself. But when you look at the issue at hand in and of itself, when looking to the First Amendment stating that Congress shall make no law respecting the establishment of religion or prohibiting free exercise thereof, by forcing those who may not affirm the existence of a particular monotheistic God in the first place to state this in a form like this is directly unconstitutional because it is acting in essence as an establishment of religion where they should not be forced to or able to, and thus this is an unconstitutional issue at hand.
Well done. You presented precedent, prior cases, put your argument together in a clear fashion. Well done. We have either a concurring or a dissenting view.
My name is Todd Benedict. I am a criminal justice major with ACC. Under God is more of an act of patriotism. I do not feel that it is religious belief. Under God was added to the pledge to fight communism and is how we today have pride for our country. Our children should grow with pride for our country and our soldiers who have died for that right. The pledge should stay required by all students because it is an act of patriotism and not a practice of religion.
Thank you, sir. Do we have any other views on this issue?
If I may speak twice.
You spoke on another issue, did you not?
I did. May I speak twice?
No, you may not.
Okay.
Do we have any other participants in that group who spoke, wish to speak on the issue under discussion? Seeing none, let's move on to issue number 12. the issue of gun regulations.
Okay. My name is Jessica Morrison, and I'm a student at ACC. I am taking a few law classes to hopefully prepare me for law school in 2014. See how that goes. So our topic that we talked about was whether the legislature from Vermont passing a law banning the sale and use of public military-style assault weapons, clips with more than 8 bullets, and the sale and use of Teflon-covered cop killer bullets is constitutional or not. My group came up with the belief that the statute itself would be unconstitutional, not because we went one way or another on gun rights in total, which we had very differing levels and opinions on, but because the statute itself is far too vague, and it would be very hard to enforce it. The vagueness that we were talking about was more the words sale and use. Does that include the sale to police officers, to military personnel? Would they have the ability to have those things to protect themselves from smart criminals or criminals in general who don't necessarily obey the law? Is 8 rounds enough for the military or police personnel? So those were kind of the vague things that we found were too much of an issue to determine whether this would be constitutional or not. So we said no.
So you found it unconstitutional, this particular regulation?
This particular legislature.
Thank you, well done. Do we have another spokesperson on the issue of gun regulations?
We do indeed. My name is Art Whitman. I'm a political science major at UT and ACC. And we found this at my table to be unconstitutional because it comes into direct conflict with the Second Amendment, which clearly states that a well-regulated militia, being necessary to the security of a free state, is the right of all the people to keep and bear arms, and that shall not be infringed. A ban in itself is a direct infringement of this amendment. Now, the Second Amendment also is the only amendment that comes with a preamble. It is where it states that a well-regulated militia being necessary to the security of the free state, which is the preamble itself. We as citizens are the militia. The second part of this amendment states that it's the right of us, the militia, the people, to keep and bear arms. And any ban whatever it may be, is an infringement of that Second Amendment right. Thank you.
Thank you.
Okay, my name is Heath Johnson. I'm an ACC student at Rio Grande, and I'm here to present a pro-view of dissenting view as far as collectively individual, collective safety, rationally. Collective safety outweighs rational individual rights to bear arms within reason.
Thank you, sir. Thank you. A variety of different positions on a very hotly contested issue. Do we have any other spokespersons on that issue? All issues have been addressed. We have had an evening deliberating and discussing and debating the Constitution. We've done so civilly, intelligently, and hopefully you've had some fun. Some people would say, can you imagine a group of students getting together for 2 hours and discussing the Constitution and constitutional issues? What a better way, I can't think of a better way, to celebrate the birthday of this magnificent document. Give yourselves a hand. All of you should be able to now receive your certificates of participation. They will be distributed. Thank you and good night.
Your slips that you need to get credit for your professors can be picked up at the back,
Do not leave if you want credit with your professors without it. Facilitators, please come forward. Facilitators and guides that are still here, please come forward. We want to get a group picture. Facilitators and guides, please come forward. We want a group picture.